Please take your seats. Caribbean Court of Justice Appellate Jurisdiction on appeal from the Court of Appeal of Guyana, CCJ application number 7 of 2019 between Zulfikar Mustafa versus the Attorney General of Guyana and the Chairman of the Guyana Elections Commission, the second respondent. For judgment this afternoon, can we have the appearances for the court, please? Thank you.
Mrs. Zubalan, Mr. Douglas, Mendez meets me, Davish Maraj, Mr. Kamil, and Dalal, Mr. Fatis Satram, Mr. Marcia Gabi Sharma, who is instructed by Ms. Candice Barr for the appellant.
Yes, good afternoon, Council.
I'm finishing up the appearances.
Oh,
AG.
May it please the court, in accordance with the Attorney General, Mr. William Senior Counsel, Mr. Jerome Rajkumar, for the Attorney General. We're trying to figure out if we're calling all the appeals together.
oh no. We are doing them serially. Well, there are a consolidated set of cases involving the no confidence motion. We're not dealing with that just yet. We want to deal with the GCOM, what we call the GCOM case at this point. So I think there's only the Guyana Elections Commission.
Please, Your Honors, Attorney General in person, in association with Mr. Ralph Thorne, UC, and Mr. Hadwell, UC.
And Mr. Marcus, you're for the Elections
This
Commission.
is, Your Honor, for the Elections Commission.
Yes, thank you, and good afternoon again, Council. We have a very short judgment to encompass the orders that we...
Pardon me, Your Honor. Pardon me, Your Honor.
Yes, Mr. Gollop.
Good afternoon.
Yes.
Please permit me to tender an apology for the absence of Mr. Ralph Thorne, QC. He's been unavoidably called away.
Yes. Thank you.
I'm obliged to you, sir.
Yes. Yes, as I was saying, that we have a very short judgment which I would read in its entirety, and that judgment encompasses the orders of the court in this particular matter. It is a judgment of the entire court in which all the members of the bench, including Justice Hayton, who is not with us, have contributed. This case involving the Guyana Elections Commission, or GCOM, was brought to determine the lawfulness of the appointment of its chairman. The case was heard on 8th May 2019, immediately before the hearing of a consolidated set of cases that dealt with the validity of a motion of no confidence passed in the government of Guyana on the 21st of December 2018. And we refer to those cases as the no confidence motion cases. On the 18th June 2019, this court rendered its judgments in each of those sets of cases. In each case, the court arrived at a number of conclusions without making specific declarations or orders. In this, the GCOM chairman case, the court concluded that the process resulted in the unilateral appointment by the President of a chairman of GCOM was flawed and in breach of the Constitution. As occurred in the no confidence motion cases, counsel involved in the GCOM chairman case requested that the court should not make any consequential orders on the above conclusion without first hearing submissions from the parties on the nature of the consequential orders that should be made by the court. The court acceded to this request and accordingly ordered the parties to make written submissions to the court no later than the 1st July 2019. Since the two sets of cases are in some respects related, the court received submissions covering both. The need to issue consequential orders and directions in this case has been rendered largely unnecessary because we understand that the GCOM chairman has voluntarily resigned his office since the delivery of our judgment on 18th June 2019. It is now a matter of the greatest public importance that the President and the Leader of the Opposition should, as soon as possible, embark upon and conclude the process of appointing a new GCOM chairman. This imperative is now of the utmost urgency in light of our decision in the no confidence motion cases that the motion was validly passed, thereby triggering the need for fresh general elections. The court refers to the views we expressed at paragraphs 26 to 29 of our earlier judgment in this matter as a suitable frame of reference for the process leading to such an appointment. In all the circumstances, it is necessary for us only to make the following declarations and orders. 1. The process utilized to appoint Justice Patterson to the post of GCOM chairman was flawed and in breach of the Constitution. 2. The said appointment was void. 3. Costs in this appeal and in the courts below are to be paid to the appellant and to be borne by the Attorney General.
Caribbean Court of Justice Appellate Jurisdiction, CCJ Appeal number 9 of 2019, between Christopher Ram and the Attorney General of Guyana, the Leader of the Opposition, and Joseph Harmon. CCJ Appeal number 10 of 2019, between Bharat Jagdev versus the Attorney General of Guyana, Dr. Barton Scotland and Joseph Harmon. CCJ Appeal number 11 of 2019, between Charandas Prasad versus Compton Herbert Reed and Dr. Barton Scotland, the Attorney General of Guyana, Bharat Jagdev, and Joseph Harmon, for judgment this afternoon. Can we have the appearances for the court, please? Thank you.
May it please Your Honours, Kamal Rampuran with Vindu Kisoon for the appellant Christopher Ram.
May it please Your Honours, I am Sanjay Dattadin, and with me is Mr. Ganesh Hira for the appellant Charandas Prasad.
If it pleases Your Honour,
Yes.
Mr. Boston with Mr. Corbin for Compton Reed.
Yes, Mr. Watson.
Mr. Jumalux, on behalf of Mr. Bharat Jagdev, Leader of the Opposition, Mr. Mendes, Leadsme, Devish Paraj, Mr. Anil Nandalal, Mr. Chandrapati Satram, Ms. Masin Nadi Sham, instructed by Candice Bharat in all matters.
Please, the court, Eamon Courtney for the Attorney General, I appear with the Attorney General and Mr. Jerome Rajkumar in all matters. Obliged.
May it please Your Honours, Stanley Marcus, appearing for the Guyana Elections Commission.
Yes, thank you very much, Counsel.
May it please Your Honours, Rashid Khan with Mr. Teddy Wuski, appearing for Dr. Barton Scotland.
Yes, I thank you, Counsel. I take it that concludes the appearances. Okay, Mr. Ford gave his appearance. Yes, yes. This is a judgment of the court which has been contributed to by all the members of the court, including Mr. Justice Hayton, who is not with us today. These cases were consolidated and heard together on the 9th and 10th May 2019. On 18th June 2019, this court rendered its judgment in which it reached a number of conclusions, but stopped short of issuing any orders. Counsel for the Attorney General and for the Leader of the Opposition, respectively, had previously jointly requested that the court should not make any consequential orders without first hearing from the parties. Accordingly, the court ordered the parties to make written submissions to the court no later than 1st July 2019 on the orders and directions the court should make in light of the conclusions arrived at in the judgment. The court gratefully received written submissions from counsel for the Attorney General, the Leader of the Opposition, the Guyana Elections Commission, Mr. Sharandas Prasad, and Mr. Joseph Harmon. In choosing now not to rehash these submissions, the court intends no disrespect to counsel. The submissions were useful and helpful and have been fully considered by the court. Due observance of constitutional democracy and the rule of law in Guyana rests in large measure with the conduct of the various branches of government, that is, the President and the Cabinet, the Parliament, and the judiciary. All must be faithful to the spirit and letter of the Constitution and operate within the parameters given to each by the Constitution. Article 106, 6, and 7 of the Constitution states as follows. 6. The Cabinet, including the President, shall resign if the government is defeated by the vote of a majority of all the elected members of the National Assembly on a vote of confidence. 7. Notwithstanding its defeat, the government shall remain in office and shall hold an election within 3 months or such long a period as the National Assembly shall by resolution, supported by not less than 2/3 of the votes of all the elected members of the National Assembly, determine, and shall resign after the President takes the oath of office following the elections. The judiciary interprets the Constitution, but as we intimated in our earlier judgment, these particular provisions require no gloss on the part of the court in order to render them intelligible and workable. Their meaning is clear, and it is the responsibility of constitutional actors in Guyana to honor them. Upon the passage of a vote of no confidence, the article requires the resignation of the Cabinet, including the President. The article goes on to state, among other things, that notwithstanding its defeat, the government shall remain in office and that an election shall be held within 3 months or such longer period as the National Assembly shall by resolution, supported by not less than 2/3 of the votes of all elected members of the National Assembly, determine. The Guyana Elections Commission has the responsibility to conduct that election, and GCOM too must abide by the provisions of the Constitution. Given the passage of the no-confidence motion on 21st December 2018, a general election should have been held in Guyana by 21st March 2019, unless a 2/3 majority in the National Assembly had resolved to extend that period. The National Assembly has yet to extend the period. The filing of the court proceedings in January challenging the validity of the no-confidence vote effectively placed matters on pause, but this court rendered its decision on 18th June 2019. There is no appeal from that judgment. Article 106 of the Constitution invests in the President and the National Assembly, and implicitly in GCOM, responsibilities that impact on the precise timing of the elections which must be held. It would not therefore be right for the court, by the issuance of coercive orders or detailed directives, to presume to instruct the bodies on how they must act and thereby preempt the performance by them of their constitutional responsibilities. It is not, for example, the role of the court to establish a date on or by which the elections must be held, or to lay down timelines and deadlines that, in principle, are the preserve of political actors guided by constitutional imperatives. The court must assume that these bodies and personages will exercise their responsibilities with integrity and in keeping with the unambiguous provisions of the Constitution, bearing in mind that the no-confidence motion was validly passed as long ago as 21st December 2018. It is important, however, that the court makes this point. In mandating that the government shall remain in office, notwithstanding its defeat and the resignation of the President and the Cabinet, Article 106 envisages that the tenure in office of the cabinet, including the president, after the government's defeat, is on a different footing from that which existed prior to the vote of no confidence. Chancellor Cummins Edwards, citing Peter Hogg, the Canadian constitutional expert, was right to note that, and I quote, "The government continues in office as a caretaker government or an interim government until the next elections ensue, and a president is appointed or reappointed, depending on the results of that election," unquote. By convention, the government is expected to behave during this interim period as a caretaker, and so restrain the exercise of its legal authority. It is this caretaker or interim role that explains the 3-month deadline in the first instance that the article lays down in principle for the holding of the fresh elections. In all the circumstances, the court makes the following declarations and orders. 1. The provisions of Article 106, 6, and 7 of the Constitution apply to a no-confidence motion. 2. 33 votes constitute a majority of the 65-member National Assembly. 3. Mr. Sharandas Prasad was ineligible to be elected to the Assembly by virtue of his citizenship of Canada, but his vote on the motion of no confidence was valid. 4. Nothing in the anti-defection regime established at Article 156(3) of the Constitution rendered Mr. Prasad incapable of casting his vote on that motion in the manner in which he did. 5. The National Assembly properly passed a motion of no confidence in the government on 21st December 2018. 6. Upon the passage of this motion of no confidence in the government, the clear provisions of Article 106 immediately became engaged. 7. Costs are awarded to Mr. Jagdeo and Mr. Prasad respectively to be taxed if not agreed. In each case, those costs are to be paid by the Attorney General. In the case of Mr. Jagdeo, those costs are certified fit for 2 counsel. And Mr. Ram is awarded 60% of his costs to be taxed if not agreed. Those costs are to be paid by the Attorney General. Copies of this judgment will be, and the previous judgment, will be given to counsel immediately, I believe, and will be put up on the website of the court before the close of business today.
Court rise.